Hey, it's Sela Social Studies.
Hey guys, welcome back to Sela Social Studies. Today we're going to be covering something else that happens in George Washington's tenure as president, and it's going to be the Judiciary Act of 1789. What is the Judiciary Act? Who does it deal with? What does it do? Think about this, right? Articles of Confederation created one branch of government, the legislative. You had delegates from the states who can go there and vote on things. Remember, nothing ever got amended. You had very little laws passed because you needed 9 out of the 13 delegates to agree. And so what, right? So remember, the Constitution fixes that, right? It fixes those problems that the articles were short of. So now we had 3 branches of government. You had the executive, the president, and the vice president. You had the legislature was Congress. And now you had the judiciary branch. So why do we need a Judiciary Act? Well, here it is. The Judiciary Act of 1789 is needed because the Constitution gave us the judiciary branch, but it didn't give us any instructions on how to use it. So it was needed because the federal court system had only been sketched out in general terms in the Constitution. Here you go, guys. Do something with it. It was kind of all over the place. We didn't know what to do in certain courts. What courts had the rights to do what? Was there one court that was better than another court? Was it a higher court, a lower court, just like the houses, the Senate and the House? What do? We had to figure this out, and this is what the Judiciary Act of 1789 does, right? We had no court what court would do appeals. So here they are. It's an act establishing the organization of the U.S. Federal court system. Now, the Judiciary Act of 1789 established a 3-part judiciary and outlined the structure and jurisdiction of each branch. And I'm going to go in them right now with you. So the first one, kind of the smallest one, the bottom tier one, is what we call district courts. Districts, our country is divided into districts, smaller districts, and each district has one court and one judge in each, and they are responsible for civil, which is like monetary things, and criminal actions in their districts. So you were in this district, you did something bad, you're going to get tried in that district. If you're suing somebody for whatever reason, it's going to be in that district. You're not going to go to another district. The Judiciary Act actually creates the attorneys general as well. So now we have the Attorney General of the United States, and you have district courts, smaller courts with small-time criminals, I guess you could say, right? The next one we have is circuit courts, and the circuit court is the second biggest, the one above the district courts. They are the middle tier of the federal court system. They are created to serve as principal trial courts. They also exercise limited appellate jurisdiction. So here you go. Here's where you would bring your appeals to. You have a local district judge and 2 Supreme Court justices that preside over circuit courts. So you have district courts, the smallest, circuit courts are the mid-tier, and then you have the big guy, the Supreme Court of the United States. When the Judiciary Act was signed, the Supreme Court was composed of 1 Chief Justice and 5 Associate Justices, and all the decisions of the Supreme Court would be final. Right? You can't appeal Supreme Court decisions. Now we have 9 justices on the Supreme Court, and you have to have an odd number on the Supreme Court so you can have a decision every time. Because if each decision is final, you have to have a resolution to a case. The power to settle disputes between states and review of the final judgments of the highest court of any state. So the highest court in a state has a judgment, the Supreme Court can review it. They also review all state court judgments in cases arising under the Constitution. That means the Supreme Court deals with cases that have to do with the Constitution. The Supreme Court has a lot of power now. Remember, they can kick back a law saying it's unconstitutional. They can decide on big-time constitutional cases. When you talk about Brown versus the Board of Education, that's a Supreme Court case. When you talk about Dred Scott versus Sanford, we'll learn about that later. He's a slave who sues for his freedom. That's a Supreme Court case. These are things that deal with the Constitution. So meanwhile, the Constitution fixed the problems of the Articles of Confederation. It did not give us an instruction booklet on how to do some things. The Judiciary Act of 1789 is that instruction book on what we could do with the court system.